There we go. There we go. There we
Okay, I got the notification.
go.
I just finally got to the right Dropbox, so I apologize for that. I don't
Oh, you're
see
good.
a habeas. I don't see a habeas. One, do we want to use our get a PCR draft and use that as a starting point?
So I want to keep the documents on our end separate, just because they are different practice areas. But there's no federal right to counsel for habeas. I don't think there's a federal right to counsel on PCR either, but I'm not 100% positive.
No, so I just did all this research because I told the court the wrong thing. It's statutory in Oregon.
Yeah.
And that's what sets Oregon apart is a lot of states, most states don't appoint. Well,
Yeah.
it's not statutory in most states, so they don't appoint.
Well, and I know that like you can have counsel, but it's not required. Like I forget what the case was just a little bit ago, because I had to do some research because somebody asked us about it too. Anyway,
Yeah, and in Oregon, it's statutory.
so and it's a devil of a thing trying to find good any relevant materials because there are so few states that give you any counsel on those. So so I do want to keep the two documents separate for now, and then we'll combine most of the stuff that we create into one coherent document. I mean, frankly, I would be ultimately surprised if we even incorporate them into the qualifications document that we have eventually. It'll get voted in by the commission in a vastly different timeline. So.
And I didn't want to suggest a merger. I was just saying simply, if there is no template, maybe our PCR document becomes the template.
Oh, sure. That totally makes sense to me. So we would start out with like role for the client and then or role of the attorney, whatever.
Is there a OSB standard for habeas?
I don't
No?
think I found one.
I haven't seen.
Okay. So should we just start using the OSB standard for post-conviction and take out what we don't want?
Sure.
Okay.
Again, like totally free form. We can do this however makes the most sense for everyone else. Let me go ahead and I did leave those in. Let me go ahead and share screen. You can see the working area that I've got going. But I'll have to take notes some other way because those check marks are not for those are for PCR, not habeas. Okay.
Yeah, I would just start at number 1, role of habeas counsel.
Yep.
And then we'll have to come up with a paragraph because we obviously can't use it.
Yeah. Okay. With this possibly more than with PCR, also keep in mind that we did split out types of, let's see if I can pull up the document, types of habeas proceedings for different types of representation. And let me see, is this? I think this, I don't remember. So there has been a little bit of feedback from the commission since these got presented, and it may be that there's going to be a small collapse of the habeas point, like the qualification standards. But we'll deal with that, I guess. But keep in mind that we did explicitly separate medical habeas from the conditions of confinement from the authority to confine. And when we're putting together performance standards, we can have some apply to only one or the other, or both. Like we can be freeform in how we want to make that work. Since there may be dramatically different ways that an attorney would operate between those two types. So,
Yeah, I think one that this is kind of like being aware of like federal habeas corpus rules and PCR for habeas, being aware of and like informing your client about the like ability to file a civil lawsuit. And I think that would apply for both types. So that would be about like statute of limitations, preservation, yeah, any effects on like settling a case, that kind of thing.
okay.
But I should know this question, and I don't. So if you lose your state habeas corpus, can you eventually find your way up in federal habeas corpus?
No, you'd be doing, well, for like conditions of confinement, you'd be doing like a 1983.
Sure, yeah, I understand that.
I don't know about authority of confinement. Could you do federal habeas?
They do apply res judicata collateral estoppel in federal
Yeah,
habeas if
exactly.
you lost your state habeas.
Yeah.
Yeah, I know that, but Meg, what I heard you saying is that in terms of statute of limitations between the post-conviction and the federal, I mean, we're not talking about the federal
Not for
habeas.
federal habeas, but for, I guess, I wasn't meaning federal habeas. I was just
Okay.
meaning.
It would be a
like,
1983 or a tort 1983.
Yeah, or
Yeah,
a tort,
state court.
exactly.
Okay, I just
Yeah,
was,
that's all I was meaning to
I
say.
got confused because
Sorry.
I wasn't aware that you could raise a federal habeas based on a state habeas. So I'm glad that I was right. Well, I'm
Yeah.
glad that I hadn't missed
Yeah.
something.
Yeah.
Okay, so do we want to try and come up with the role of habeas corpus counsel, or do we want to think about what that paragraph should say and get back to Kevin? In terms of this little paragraph, right under standard 6.2.
This being the standard 6.2 for PCR.
Yeah. Do we want to reword that or think about it?
And this is where I think those subsections we did for the qualification standard are significant, both for having practitioners that can do this work, but also just in applicability. I mean, I only know the conditions cases, but a lot of the medical habeas is going to be different, differ so much from, another habeas that someone very familiar with criminal practice would be more familiar with. And, just the roles, I think it'd be like a criminal defense lawyer versus a med mal lawyer, I think.
Mm-hmm. Yeah, especially for like
So we
extradition.
we can split the role of the counsel and have it be role counsel conditions. Or actually, we probably use the let's see, habeas 2B, is it? Yeah. And what did we use as the HCA 2B? Is the and role of counsel. Which that would be, I think if there were going to be a collapse, it would be 1 and 2A would collapse into a single, a single
Oh, yeah. Okay.
standard. So we can split those. if the
Yeah,
role
I mean, I
is
think with
different
the,
enough.
sorry.
Go ahead.
It's just, with the first one, so with 1 and 2A, which are the like authority for confinement, those are again going to be more similar to like the PCR of understanding how these claims are different. Like a habeas condition or authority for confinement claim is different than a PCR claim and is different than a direct appeal claim, and understanding the distinctions between those is going to be important. And similarly, like with extradition, understanding the role that like a habeas case plays in extradition versus the criminal case itself and the extradition case. Because usually all three of those are going simultaneously, and it's confusing.
And we can pretty this language up later, but does that capture what you're saying
I think so.
roughly? Okay.
Yeah.
And a medical habeas.
Yeah, true. Know what you're not allowed to do as well.
Mm-hmm.
What else?
I mean, I think that people need to understand that if they lose the habeas, I mean, it really goes with number one. If you lose the habeas, then you can't file it in 1983.
Oh.
Mm-hmm.
Oh, I'm sorry, underneath the.
Yeah.
Yeah. I mean, that really goes to the res judicata that was already mentioned, but
Yeah.
on the same issue. Can't file on the same issue.
Okay.
Um, I mean, the implementation in 6.2 just really talks about what a post-conviction is.
Mm-hmm.
So do we want to just, in this implementation of this role of counsel, do we want to talk about what each of these different habeases include? Or what claims should be included?
Yeah. Yeah, that's a good point, because that is, we think of like, I feel like medical is the one everyone thinks of most frequently, but there's several others. Of just, access to the courts and religious access
Yeah.
and all of that.
Yeah.
Maybe worth listing.
So what is a list of things that file? And again, this is where I'm at a little bit of a deficit because I wasn't at the qualification standards. So the HCA1 and HCA2A,
Mhm.
what are all the different things that those encompass?
So I'll pull up so for habeas corpus 1, extradition arising out of criminal cases and related petitions for habeas. And this was just to bring in a very entry level habeas process that, are not exceedingly common, but not exceedingly uncommon either, and one that don't need a high level or high degree of practice. And then HCA 1 or HCA 2A is just authority of confinement, and 2B is conditions for confinement.
I see. I was confused.
Yep, no worries.
So it feels like I don't understand the attorney designation on the document that we're working on right now. Isn't it just roles of counsel appointed to conditions of confinement cases and roles of counsel for attorneys?
Let's just break it into authority of confinement cases and
Yeah, instead of the different designation for the attorneys. So for authority of confinement, what is a list of those types of cases? Were you thinking, is that like,
So it's like, right, it's the extradition, it's like sentencing miscalculations.
Yes.
So that can be like good time, like
Yeah.
calculating good time credit,
Mhm.
calculating credit for time served.
So I think we should list that. Good time, credit for time served. I mean, sometimes there's, and I haven't done a habeas in a long time, but as I remember, there were problems with getting sometimes the certification of days from county.
That makes sense. Yeah.
So I guess that would be a miscalculation. So miscalculation of sentence. I mean, are people still filing
Oh,
stuff
yeah.
with regard to parole board making incorrect decisions? So parole board decisions.
Segregation too, like
Mhm.
the process.
Okay, so not necessarily the conditions of segregation, but what is that? The DR,
Yeah. What
the
is
hearing?
Yeah, the hearing.
And then what about, are people raising IMU time? Like the hearings related to IMU?
I have not seen that, but I don't.
And have you
Well,
seen
no,
that?
I have seen that. Yeah.
What is IMU?
Intensive management unit?
Is that different from segregation?
Yeah, I would just say decisions related to segregated housing.
Yeah, that's good.
Yeah, so that one's the IMU's the non-disciplinary and long-term.
Yeah.
Yeah.
Okay, anything else for authority of confinement?
Not that I can think of.
Okay, so then conditions of confinement, we started the list. Um,
There's also like general physical conditions that aren't
Yeah.
like medical care, but
it's like the environment.
yeah, like environmental.
Mm.
There's I don't know if it's a single category, but you'd have like visitations, communications with others, associations.
Mm-hmm.
Something like freedom of association?
I don't know if people will know what that means.
Okay.
Well, like, what about restrictions on communications? For
Right now,
medical,
I'm just making notes. So
Yeah.
like
Yeah.
we can refine and define things further as we move through. And like that's like we're gonna have a month before the next. Oh no, the next one for this group is next week, isn't it? Hold on.
I don't think so.
Oh no, because next week is due. I swear we had some back to back somewhere. No, it must be the civil commitment one that is that back to back. We're not meeting until June 16th. Okay.
do you want to
So
do
we got a month.
mental health and physical health under medical?
Mm-hmm. And then, yeah, conditions of segregation could be, that's probably under environmental more, although it could also be under medical, but
It could be its own. We can pull that out and have it as its own.
And then Ed, or Meg, what is the case law now with regard to like safety from other inmates? Like,
what is it?
I mean, security issues.
Like duty to protect.
yeah, yeah.
Yeah. It's not favorable. That's what I'm saying. Doesn't get very far in mine.
Those feel like the big ones. I mean, under religion, there's different subcategories in terms of religious objects versus observation of, holidays versus religious food.
Yeah, and I think part of what for like just what the paragraph can say is like not only understanding each of these claims that could be raised, like the kinds of claims that can be raised, and also the different standards that apply to each of them.
Okay.
Should we move on to communications with client?
Sure. And do you think that this would apply the same regardless of the type of habeas action?
I do. What do you think, Ed?
I would assume extradition or something like that is going to happen really quickly. It's going to be a fast moving, whereas a medical habeas could be fairly slow depending on county and facility.
What about the first contact for each kind of category? Oh, I see what you're asking, Kevin, if they should be broken out.
Mhm.
Okay. I don't know, Ed, what do you think? Should they be broken out into two different subsections for communication?
I can't think of anything other than extradition that would be really quick. The rest seem relative similar time frame. I mean, I suppose with an over detained sentencing kind of issue, you can have someone who was supposed to be out last week.
Yeah,
Which
I
like
mean,
they
they're all
can't
supposed
file
to
the
be
habeas until that's
urgent.
passed.
Right, yeah. In theory, they're all, urgent. Could just put, but like
Well,
extradition does have a
the
different.
court
court doesn't think so.
Does not feel the urgency with some
No,
of these.
no, they don't.
maybe would that break down into where you're no, it wouldn't break down where you're confined because would you have an extradition that wasn't in county jail? You certainly could have the over detention in DOC, but and if we're using just the word first contact, I think it should be upon appointment. If we're not being more specific about contact.
I know in the PCR group, we just put 14 days for initial contact instead of using the terms upon appointment.
Well, so my very, very, very limited experience with extradition, I mean, it was done in less than 14 days.
Yeah.
That thing was wrap, so.
The couple of them I handled, it was largely just go speak with the client the same day. And I mean, even before, like they were just on the arraignment calendar, and a lot of the times they knew they wanted to waive ahead of time, so they just did it in front of the judge at the arraignment. Okay, so for extradition, do we just like, is it impractical to put a number here? Is that the, because
Just for the, if you're talking about someone who's, past their release date, past extradition, I think it doesn't need to be too dissimilar from PCR, but for those other two, obviously time's gonna be of the essence.
Okay. I know the criminal standard is like, if somebody's held in custody, it's within 24 hours that you have your first contact with them. Does that seem like a good backstop at least?
For like extradition specifically.
Yeah.
I mean, yeah, maybe. I don't know how practical that is, but at least to determine what kind of extradition situation it is, if it's like
I think this might be
happening
where Joe is maybe the
yeah.
the one to talk to more on this. So we can pend this for Joe's input.
It's good.
We didn't get very far with client communication in PCR, but then we had a lot more other stuff to discuss, like framework wise, before we got rolling. We can push further on this. What should contact look like on an ongoing basis? Or is that something
It's
that
going
we
to depend. In my experience with the medical issues in DOC, you can have a lot happening frequently, whereas with the religious issue or access to courts, you're not gonna, that's likely gonna be a little more static of what's going on.
Let me, you know what, I'm gonna go ahead and organize this differently. Let's go with just one client communication, and we'll do first contact, extradition. Days. There, that might make a little bit more sense. Sorry, go ahead, Ed.
I was just saying, I think for some, certainly for some medical habeas, you're gonna need pretty frequent contact. But I can't, like with the access to courts or a religious issue, it's not gonna change, or if it does, it's gonna moot the habeas probably, so.
I mean, I think one thing that we could easily put in is, they're required to send all pleadings within a week.
Okay. And that would be everything.
I think so. I mean, I think, don't you actually have to indicate that you've put the pleading in the mail to your client at the same time as you file it? Let me look at a certificate of service.
I think that's just the PCR UTCR, I think.
Oh, it is? Okay.
I may be wrong about habeas, but I don't think there is anything in habeas.
Okay.
Yeah.
Do you think in-person contact is needed, or is phone sufficient? Or
I think it's too hard to require that,
Yeah.
especially when you're getting clients out of Lake County.
all over the state? Yeah. I just noticed that in the OSB standards for PCR that they
Yeah, I don't.
in person. Yeah.
So I will say, to me, this calls in a lot of the, calls to mind a lot of the dependency standards around representation of kids, in which we set up here. Let me see if I can pull it up real quick. We have in the dependency framework for representing kids, There's actually timelines in the standards about how frequently a kid should be seen. And it's basically in advance of every important event, if possible, shortly thereafter, if not possible to see them before, and no less than quarterly. The first contact should be in the client's home and in person. After that, it can be whatever is necessary for the attorney to maintain a relationship with the child client. That's just kind of an idea of, because with this, we've got the longer, you've got clients all over the state. Kids get placed everywhere. I've been to Iowa to visit one of my kid clients. Nobody's saying that you have to be there every 3 months in Iowa, but seeing where they are in placement is very useful for getting to know the environment that the client is in and how it's how it impacts their case.
And I do think
we do pay. OPDC does pay for attorneys to go visit their clients, as even out of state. So that it's really the finding the time that is the biggest difficulty.
well, maybe we should require in-person visits. I mean, that, to me, a lot of times that's what maintains the client relationship, is if you have face-to-face with them, regardless of where they are.
Mhm.
And there are a fair number of, like with medical habeas, there can be like psychological stuff going on as well. And building that relationship, I think it seems like works a lot better in person and is really critical to making the case work.
I think there may be some medical issues where the client doesn't want to be taken down to the visiting room, wheeled down, or, inconvenience. Depends on the facility too. Some facilities are easier than others.
No, that's true too.
So we can certainly put in exceptions. I mean, there are for the dependency standards. One of the big ones being if your kid says they don't want to meet with you.
Yeah, I think that's a big one. That can be the exception if your client doesn't want you to come out.
If it's a hardship, because you may have one with real mental health issues that maybe can't express it. I don't know. Geez, I did one visit at the state hospital, and that place it did not look at all like a state institution on the inside. So.
It's
Yeah.
really up to you guys. Like,
I think we should put it in there. We can, I mean, it's not the final draft. We can think about it, but I think we should have it.
Yeah. Okay. All right. Anything else related to communication?
I mean, I do think that the attorneys need to be obviously in contact with their client. I just don't know what the right number is.
Right. Yeah. Or like how to.
That can certainly be something that we take the time before our next meeting to nail down a little bit better. Posing a question, an alternative question. Mental health is one of the types of things that could come in. How does capacity interplay into the role of the attorney here? I mean, we dependency attorneys explicitly have, when you're representing a kid, and the rule that kind of everybody's aware of is if they're less than 7, you're likely substituting a lot of judgment for your client. You still do what you think they want you to do rather than what's in their best interest. But you're aiming for, you're filling in the gaps of what they can't, how they're unable to direct you.
And that's a really tricky question, because I've had this situation come up in a post-conviction and got a guardian ad litem appointed. And what I understand from my ethics attorney is that you essentially can't represent somebody that's not competent. maybe that's just in the context of a post-conviction. I don't know. I've never seen a guardian ad litem being appointed in a habeas. I think that's an extremely complicated question because in a habeas, they initiate the proceeding. And so it would appear that they would at least be competent in the sense that they, and it's not an aid and assist. That's not the, that's not what you're looking for. You're looking for whether or not they can basically conduct daily activities. So if they file the habeas, it seems like they would be competent to make decisions about the litigation. I don't know. I've never seen a habeas filed on somebody's behalf. You guys have any thoughts? I just don't know.
ORCP 27 requires the guardian or conservator to appear for an incapacitated person. But the question is, yeah, if you're representing them in a habeas.
That's different though. That's the guardian, and that's the guardian statute. It's the guardian ad litem statute. It's totally different. Is that the guardian ad litem statute?
No, minor or incapacitated parties.
Yeah, that for
But
guardian ad litem, so representation at a legal proceeding or in general.
If a person's incapacitated under the ORCPs, they can't appear in their own behalf. But the question of with the habeas is, I mean, you would likely have to go through the capacity, initiate the capacity proceedings on their behalf. But if you're looking strictly at the rules, if the person is incapacitated, they can't really appear without guardian or conservator.
So question, because this is probably very different from dependency, but that is my experience. Our dependency standards specifically say that we're not allowed to request a best interest attorney, but that's different in the parent's case because a parent, the guardian ad litem, is not obligated to act in their best interest, but is obligated to do what they determine that the client wants. So I don't know how that interacts with ORCP 27. My familiarity with that rule is fairly limited.
Right, but what I'm saying is that the guardian ad litem is not an ORCP 27 guardian. A guardian ad litem is under ORS 419B. It's completely different. The standards are completely different. The guardian ad litem is only to protect the person's right in a specific proceeding.
Yeah. No. And that's and there's the guardian, sorry, we may be mixing terms here. There are guardians ad litem in the dependency, in the chapter 419B to help parents through the proceedings, but those are also charged with doing what the client is looking to do. And I don't know, is that the same as the ORCP 27 standard?
I don't know. I haven't ever litigated it under ORCP 27. I've only done it as a guardian ad litem because to get a guardian ad litem is much easier than to get one under ORCP 27 because you don't need the visitor appointed. You don't need any of that. You essentially just need an opinion that they can't take care of their daily functions. And so anyway, I think this is what we should do. It doesn't sound like any of us have enough information to tell other people what to do if the person doesn't have capacity. So I think we need more information.
Okay.
And I don't know if that's from an ethics attorney or what, but I would just feel really uncomfortable telling somebody what to do with an incapacitated client when I'm not sure.
It's clear to me. No, it's clear to me you can't represent that person who is incapacitated without a guardian ad litem, guardian or conservator. The question is, if I'm a habeas attorney, I'm most likely going to have to be the one who figures out if they're incapacitated or not.
Sure. Well, yes and no, and it just gets so complicated because if your client doesn't want the guardian ad litem, you can't do anything adverse to your client. So you can't
Correct.
advocate for the guardian ad litem.
And in the dependency context, you're not allowed to ask for one, but you're also not obligated to try and prevent one if somebody else does.
You know, there's
So-
a article, a state bar ethics article dealing more with elder, but it touches on these. Maybe we want to drop a reference to that. I think I can find it, but I think there's kind of an analysis of how to deal with this. You know, when your client may not have capacity, we may just want to do like a refer to, you know, state bar opinion or article.
Yeah. Or refer them to the two statutes.
Okay.
I just
I'm gonna-
don't, yeah. I don't know.
Uh,
I don't know. Go
I
ahead.
can certainly, we can look for more information on this front. It's, at least we've called the question at this point. We just need to search for others, and I can see about us getting in touch with the bar's ethics council to see about how they would work on this too.
Yeah, because
Do we-
the problem
ahead.
is that if your client's incapacitated, then eventually, and you don't do anything, eventually the state's gonna file a failure to prosecute, and the
Yeah.
case is just gonna get dismissed, regardless of if it's a habeas or post-conviction.
And that was going to be my next question is there a difference here between PCR and habeas? We didn't get to this on the PCR side, but we can certainly, you know, move whatever we look at here into that standard list of standards as well. And I know it would be dramatically different in the criminal context, so this certainly isn't something that we would pull there. If your client's incapacitated from a criminal context, you start aid and assist procedures, right? So, and we have guidance in dependency about what we do. What we don't have is a body of knowledge here on the other stuff.
Yeah, I mean, I can talk about my experience in post-conviction if we want to go there. I'm happy to do that later when we're talking more about post-convictions.
Well,
Whatever.
I think the issue too is, again, assuming I don't know how Junior would come down on this, but generally post-conviction habeas, they say it's a civil case, it's civil proceedings, those rules apply. And that's the difference, because dependency has its own set of statutes.
Oh, yeah.
Criminal has its own set of statutes. So they are the same in terms of if you're concerned both civil cases under the ORCPs, that's how they account for that versus dependency and criminal.
All right, well, let's hold out. I think we've hit a kind of a barrier on this topic for now. We'll want to spend some more time considering it over the next month or so, and maybe come up with something by the time of the next work group session. But let's see if there's another thing we want to try and tackle before we break for the day. Let's see.
Okay, so did we get the timing down for the client communication, or are we thinking about that?
I think that is where we were.
Okay, okay.
And we were talking about sending the
Maybe-
pleadings within a week.
Yeah.
Um,
In the OSP standards, in 6.3, 6.35, it's not like
Right.
specific, timeline, but it's just kind of the things the council needs to keep the client informed about, which might be that seem generally applicable.
And I think I agree with that. And then also with paragraph 6.
Yeah.
I mean, not just, it's going to be different, but just in terms of what happens if you prevail in a habeas versus what happens if you don't prevail, and kind of what the client should expect.
So maybe that's just more subjects to make sure that the communication exists for.
Yeah, I mean, I think it looks like how the OSB is structured is just in terms of letting them know what happens at the end of the case.
Yeah. Okay.
I think for these, we kind of mentioned this, but just there does need to be like, I don't know, like regular check-ins, I guess, just to understand how things are changing, if they are changing at all. I think that's especially with medical care. I'm not sure it's as applicable, like Ed was saying, for kind of some of the other ones that kind of just are a status quo and just kind of stay that way.
Okay.
Medical
But I
care
think-
stuff can change quite a bit.
I think what I'm hearing though is that those don't need to be in person. Those can be like regular phone calls.
Right. Yes. Just like, it's not just attorney informing client about what is happening in the case. It also needs to be, attorney contacting client to make sure to like find out what is happening on the ground factually, which will help develop the case.
So Kevin, I had a question. When you were reading the communication standards for the dependency, when you said quarterly, what was that a quarter of?
A year.
Okay.
Yeah. But within like, I think, well, let me see if I can pull up the actual.
I figured, but I didn't know. So every 3 months?
Yeah. Yeah, and then if the attorney's just determination of whether that needs to be in person, or if the ends of the client are served by other communication. But basically, you need to be checking in at least once every 3 months with your client.
The state bar rule 1.4 is keeping client reasonably informed about the status of the matter. With that as the starting point, there's obviously reasons why we might want to be more specific, but all the ethics rules I know of are general like this, reasonably informed about the status of the matter for a lot of reasons. Although it does also include promptly comply with reasonable requests for information, which some clients with the habeas are going to be very active and communicative and some not at all.
I like that qualification.
Yeah.
That you have to respond to your client, or you need to. I kind of like the quarterly language. I think that's a good floor that you should try and talk to your clients every 3 months, regardless of what's going on.
Okay. I mean, if you're okay with it, I can just, as a sample, pull the language from the dependency standards. And because it basically says the attorney should determine whether the needs of the client mean that it needs to be in the client's environment, or if the ends are served by other communication means. So. Okay. Okay, this again feels like a stopping spot. So I think we can go ahead and pull this out for today. Our next meeting for the small group isn't until June 16. But we have the full group. When is that one? On the 4th of June. So I will see everybody back, and by all means, like, I will send out videos and updates and drafts and stuff. And I know y'all are communicative in that arena as well. So I look forward to the further discussion. All right. Thanks, everybody.
Thanks, everyone.
Have a great rest of your day.
You too.